Looking forward to chatting with you all. Many of you sent in questions ahead of time as well, so I've made sure to highlight some of those to incorporate them into the presentation today. I always have to give the disclaimer at the beginning that these are kind of educational presentations, not meant to be taken as personal legal advice to you. You should still be doing, most of what we're going to talk about today with an attorney. But I appreciate you all being here. Before I dive into today, we're really going to focus on estate planning and estate planning tools and estate planning in Maine. Estate planning can be really different from state to state. There's a lot of very good things about estate planning in Maine. And that's going to be kind of one of my big themes today is there's lots of like blog posts, or sometimes people have really bad experiences with like probate in Massachusetts or New Hampshire. Things tend to run a little better here. And so we'll be going over that today. What we're not going to cover today is something called main care planning. So how to shield your assets in order to become financially eligible for main care. The first step is laying the groundwork. So kind of things you want to be thinking about before you even sit down with an attorney or to start working on your estate plan. I've put together this checklist for you. So it includes things you're going to talk about with an attorney and things you're going to be thinking about beforehand. First one is your advanced healthcare directive and durable financial power of attorney. We're really going to dig into those today, what those tools are, why they're so important. But before you go to do any sort of estate planning review, it's good to see if you have these documents already, because sometimes we do them, we set it and forget it. Anytime you're thinking about doing an estate planning update, you want to see what documents you've done in the past in case we need to revoke those. And healthcare directives in particular, sometimes we get those from our primary care office or during a hospitalization. We don't even remember we've filled those out. So that's why it's a good thing to get those together. I know my firm, most firms where you're going to have an estate plan done have some sort of client questionnaire. And as part of that, you're going to review your assets. What do I have? Real estate, retirement accounts, bank accounts, any debts, mortgages, how are they titled? This is your kind of opportunity to do that information gathering. I can tell you from an estate planning, as a drafter, it makes anytime I sit down with a client, I've reviewed that ahead of time, and it just makes the consultation even more productive because I have a sense of what the big picture is, and what we need to do. Again, existing estate planning documents. And I would say that's important even if you plan on revoking them, right? Because we want to know what they are, especially for trusts. If people have, it sounds silly to think that you might forget about a trust, but I've seen it every once in a while. Someone set one up a really long time ago. They thought it was a will, and they're like, oh, I guess that's there. Let's make sure we're taking care of that. You're going to look, part of estate planning is, and we'll get into this a little bit, talking about estate and gift taxes. You're going to gather information on any gifts you might have made. Now, not small gifts like graduation gifts, birthday gifts, but if you've done any significant gifting in your family or to a spouse, we're going to consider ancillary proceedings. So what that means is, what happens if you die and you own assets in another state, and how are we going to plan for that? The most common example of that is real estate. We work with a lot of families here who, live out of state, but are fortunate enough to have camps in Maine. You will be talking about planning for long-term care, which again, we talked about at the top of the call today. I have a whole separate presentation on that. But as part of that, it's good to see if you have any long-term care insurance policies, you want to bring those in as well. Again, business arrangements, any burial or funeral, like if you have a prepaid funeral plan. And then think about if often people might make charitable gifts as part of their estate plan. So doing kind of some of that thinking ahead of time to see if that's something that you want to do. So I realize that's a lot of homework from the jump, right? But if you end up working on your estate plan, it is nice to kind of have some of these conversations ahead of time and do some of this information gathering first. All right, let's talk about your estate planning documents. So again, the two most important documents that have to do with who is going to have the authority to help you during your lifetime are the Advanced Healthcare Directive and the Durable Financial Power of Attorney. And these are the documents we think of that are important for planning for incapacity. So in the event of my incapacity, who is going to help? The first one we'll talk about is the Advanced Healthcare Directive. So this is a combination of a healthcare power of attorney. So who gets to make healthcare decisions for me if I can't speak for myself? And what's known as a living will, where you can include some end of life wishes, burial wishes. We'll kind of walk through what those different options are. Um, why do one of these? I have to tell you, often when I'm seeing folks for an estate planning update, it's because they maybe just worked on an estate for a loved one and they were like, I wish that had gone smoother. I want to do some planning in advance. And so reasons to do it are to make your wishes known, to provide peace of mind, help loved ones know what to do in the event of an illness, injury, or incapacity, and then avoid family disputes about your care or wishes. So the idea is that you know your own family best. And all of our family members have different, skills or maybe different drawbacks. And the person who might be good to help you with your finances in the event of an emergency might not be the same person you want making medical decisions for you. Um, and I should add, for married couples in particular, often they will want to pick each other, but they haven't thought yet about, all right, who's going to be a good backup for us? And so that's why that's so important. And again, if you've ever participated in funeral arrangements or anything along those lines for a loved one, it is really nice if that is written down somewhere, because I think it's something we forget that sometimes we make comments about. And I've definitely worked on matters where the family members remember that mom or dad said different things about what they would have wanted. So it just takes away any kind of possibility for family tension at what is obviously a difficult time. Um, how to do it, right? Most important question. We're going to talk a lot at it today about forms and kind of free forms you might be able to get online. Unfortunately, where things are now is that it's very easy to get yourself into trouble using a form you have found online. Really, the only exception to that is Maine Health in the state of Maine put out an advanced healthcare directive that's a free form that's available online that they update from time to time. That's very popular in Maine, that's drafted well, and that medical providers are familiar with. So that's a really, really good document to use. And again, you can get that on the Maine Health website. The big thing about it is that in order to be effective, it has to be signed by the person who is writing it for themselves. And then it has to be witnessed in front of two people. So, and then preferably notarized as well. It has two witness lines. I've seen them every once in a while where they're notarized but not witnessed for whatever reason. They have to be witnessed by two people. So that's really important. Um, I should add, for the Advanced Healthcare Directive, the reason why this document is so important is because in Maine, if you don't have one and you have a loved one who needs to start making medical decisions for you, often people will have to go get a guardianship instead. Same thing if you don't have a power of attorney, your loved one might have to get a conservatorship instead. And that involves going to the probate court. It is just far more expensive of a process than having one of these documents in place. So again, pretty straightforward document. And again, I'll just add here, I had a slide on the type of information that's typically included in the living will part. So again, most important part of that, naming your healthcare proxy and your backups. The rest of the options, or the rest of the living will portion is optional, but it's really good to think about what would I want for end of life wishes and care at that time. If you have an ongoing health issue, and you see a physician for that, including their information in this form. The idea being that if you end up in an emergency department, the treating physician is going to have the information for the most important doctor you see in your life, organ donation, and then again, funeral and burial wishes. Sometimes people leave stuff with their will about their funeral or burial wishes, it's great to include in an advance directive because that's a document that family looks at before someone passes away. So that's kind of the overview of the advance directive. I want to talk now about kind of the sister document, so that durable financial power of attorney. So this is a document where you select your agent, your person, and your backup agents, who's going to help you with your finances in the event of your incapacity. Why do it? Again, for some of the same reasons, you want to have someone have the legal authority to help in the event of an emergency. And I think sometimes people think, doesn't my spouse have that? But not necessarily. If your spouse, your spouse can't sell your jointly owned real estate without either an advance directive, without a power of attorney, or if there's accounts that your spouse has in their own name. Again, we want to keep everyone out of the probate courts and not have to go for a conservatorship. It's also really useful to avoid power struggles between family members, right? Everyone wants to be helpful in the event of an emergency, but at the end of the day, you want to be the person who's identifying the most organized, detail-oriented, responsible person to help make financial decisions for you. How do you make one? So this one is you really need to make with an attorney. I do every once in a while come across some that people do on their own, and the common issues are there are statutory notices that have to be in there. So sometimes the notices are outdated and the document's not valid or it's not executed correctly. This document has different signing requirements. So this one has to be signed in front of a notary. And we also have ours witnessed. And then for a power of attorney, you can really craft them specifically for your needs. So the powers of attorney can either be springing or effective immediately. Springing means your agent has to get a doctor's note before they can act. Some people don't like that requirement for good reason, because they don't want to have their agent, they trust their agent. They don't want their agent to have to go try to get a doctor's note before they can help. Or they want to really have that safeguard in place. Like, my person can't help me unless they get their doctor's note. We can also design what powers to include. So sometimes we do powers of attorney with what we call scaled back powers. The idea being, I just need a backup person who can pay bills for me in the event of an emergency, log into my checking account, make sure those auto drafts are coming out. I don't really need them to do much else. In other cases, it's good to have a really robust power of attorney with authority to make gifts, create trust, sell real estate. And typically, if I'm recommending that, it's because we want to be giving your agent the option to engage in main care planning. So again, separate presentation, but something to keep in mind when we're talking about powers of attorney. A couple of concerns regarding powers of attorney. So again, dangers of an unlimited grant of authority. That's why it's so important to kind of talk to an attorney, because sometimes we want those really robust powers in there for good reasons. But if that's going to happen, we need to have a big conversation about your agents, and are they responsible? Have they, never had substance abuse issues or never had financial issues? And then another thing that comes up is conflicts between the principal and the agent. So the person who created the power of attorney and their agent, when is it time for them to take over? We will always talk about strategies about when you're sharing that copy of that power of attorney. And you want to strike a balance between making sure that there are folks there to assist you in the event of your incapacity, and making sure you're keeping your finances as organized and private for as long as you want. I add a note in here about mismanagement or neglect by the agent. Obviously, you want to make sure you're selecting responsible people. There is kind of a process in the probate code where you can file a petition with a probate court to require your agent to provide an accounting if you suspect that there's anything kind of funny going on. So these two documents are documents everyone should have. I should have them. I should have them. I do have them. They're not age specific. I'll sometimes do them for like college kids who are heading off to college for the first time. You just need to be an adult to sign them. They're so simple. They don't take long to prepare, and they really, really help families prevent a big headache in the event of their incapacity. Every once in a while, I have folks that come in and just want a power of attorney advanced healthcare directive. Maybe they already have a will or don't want one for whatever reason. And that's typically at most an hour and a half of my time. And that includes, so a couple $100, right? Like the conversation we had about everything kind of I just talked about, the time, time designing those documents, which doesn't take very long, and then our time to sign. So those are typically, and you'll find that I think across the state, those are a couple $100. Um, and like some of the best couple $100 you'll spend because by comparison, a guardianship or conservatorship proceeding is anywhere from like five to, if they're contested, tens of thousands of dollars. And so we want to avoid that. Let's talk about wills and trusts. So a couple things I want to say right off the bat, and we'll kind of dive in. Um, I see a lot of like blog posts or hear from a lot of people. Everyone says I need a trust. I'm here to get a trust. In a couple slides, we'll walk through the considerations for whether you actually need a trust. In Maine, for most people, a will-based plan is going to be all that they need. So what is a will? Let's start there. A will is a document that allows the creator to state his or her wishes regarding the distribution of assets after death. Another very important part of your will is where you nominate your executor, which in Maine is known as your personal representative. So you'll hear me say your PR, that will administer your estate after you die. One really important thing to know is that your will only governs your probate assets. And a probate asset is anything that you own in your own name when you die. So it excludes joint assets, right? So if you own real estate with your spouse in joint tenancy, that's going to pass by operation of law to them at your death, depending on how it's titled. Retirement accounts often have beneficiary designations that name individuals, and that's a good thing. That's for income tax reasons. But so those are not going to pass through probate, or if you have transfer and death designations on other accounts. And so probate assets is a little bit of a reverse definition because it's everything that doesn't have a joint owner or beneficiary designation. We'll go through probate, and people hear probate, that's terrifying. I've heard all sorts of bad things about probate. We'll get into probate a little bit today. But fortunately in Maine, we have something called informal probate. And for most estates where everyone gets along and no one's fighting, we can go through the informal probate process, which involves filing an application for basically the head clerk of the probate court to review and sign off on. Nothing even has to go in front of the judge. And sometimes people ask me, like, should I just put beneficiary designations on everything or title everything? It's very common for married couples to do that, but there are still some considerations and reasons why you don't want to do that. And especially if you have assets that could pass to your children or grandchildren, that often is good to happen through a will, depending on the type of asset. And we'll get into that a little bit. Again, why do it? So if you pass away in Maine and you don't have a will, the state has a set of default rules on what happens to your stuff. So don't let the state decide what happens to your stuff when you pass away. And I would say the biggest default rule that catches people off guard is that if you pass away and you're married, it's not that everything, and you have children, it's not that everything goes to your surviving spouse. There's an amount that goes to your surviving spouse, and that depends on how many children you have. If you don't have kids or survived by your parents, whether the children are also children of your surviving spouse. There's all these default rules that, again, people and families get caught off guard by. So don't have those default rules apply. Make sure you're saying what happens to your stuff when you die. Other important parts of having a will. If you have minor children, this is where you're going to nominate who would take custody of them in the event of your death, in the event death of their surviving parent. Um, you also, and it's a little beyond of the scope of our presentation today, but Maine has an estate tax, and there's also a federal estate tax. The estate tax exemptions, meaning the estates that the estate tax actually applies to, are historically high. So in Maine, your estate is only taxable if you have more than $7 million in assets this year. That's adjusted for inflation, it goes up. And the federal level is at 13.99 million. So for most families, this is not a concern they have. For families that do have this concern, there are essentially trusts we can build into your wills. There, estate tax planning provisions we can build into your wills to minimize your overall estate tax if you're married upon the second of you to pass away. So important for those reasons. And then again, minimizing family conflicts. It definitely helps to have a will where you're selecting who's in charge of the estate and you're saying personally what has happened to your stuff when you pass. A couple of things. Again, I couldn't give a answer without seeing the will to make sure it's valid. But yes, it has to be signed in front of two witnesses. Preferably, we like to have it notarized as well. I'm pretty sure in Maine that's not required. I can look it up. Will. We always do it for all of my wills that do witnessing and notarization. But the one thing I want to flag for people is there's something called a statutory will. And I hope one day the statutory will gets better, but the one that you can find online is very, very tricky to complete because there are different sections that each have to be signed in order to be valid. So at one point last year, someone had me review a statutory will, and a bunch of important parts ended up not being valid because they weren't specifically signed. And so really, really important to get things reviewed by an attorney. Again, how to do it. There is something called a holographic will, which is where a will can be valid without two witnesses if it is in the person's handwriting. Obviously, I've handled, I think, two of these in my career. Very complicated and expensive to get those probated. And so it's very, that's not something I'd recommend anyone try to do. And there are, I think if you look up Aretha Franklin's estate, she had like two competing holographic wills. Not something we would recommend. And again, because of the way the statutory form is right now, it's really easy for people to get themselves in trouble. So again, has to be in front of two witnesses, preferably a notary as well. But the notary part is not required. I'm going to confirm that again because I would never have a will without a notary. But the idea is that you don't want to give anyone any leeway to challenge your will. Everyone who's 18 can make their own will. If I was making a will for you, you certainly can say, even though I did an estate planning update for a couple last year, their kids were 17 and 15, and they still nominated guardians, and because they're like, well, why not? And hopefully nothing happens to us in the next 3 years, but we can make that choice. And then 18-year-olds, of course, can do their own, are allowed to execute wills, powers of attorney, and advanced healthcare directives. Let's talk about what's in a will. So the first thing that a will disposes of is your tangible personal property, which is a fancy legal term for your stuff. Anything that's not real estate or financial accounts, investments, things along those lines. In Maine and a handful of other states, you can actually have what's called a personal property memoranda. So it is separate from your will, a separate note that says who you would want to receive certain items of your tangible personal property. This tool is nice because you can update it as you need to. For married couples or single people where they know they want all their stuff to go to one or two people, this is not usually an issue. People typically use this in the estate plans I'm doing because they want to leave firearms to someone specific, or they want to leave jewelry to a specific person. Wills can also include specific gifts. So sometimes people want their estate, after their spouse passes to go to their children, but first they want to make a small gift to a charity. That's fine. You can accomplish that in a will. Or if they, let's say they have like a friend or someone who's been helping to take care of them, maybe they're leaving a small gift or like a grandchild. Sometimes people will put small gifts in their will. Um, Common mistakes to avoid. So there's lots of famous cases of people misidentifying charities. And then unfortunately, the charitable organizations fighting over who gets what. So at anytime we prepare a will, where we're naming a charitable organization, we also give your executor flexibility to make a replacement gift if that charity closes or if there's any question about which charity the gift should go to. And then make sure you have sufficient assets to fund your bequests. So, um, again, remember we talked about probate assets, right? So sometimes people pass away and actually they have no probate assets. All of it was beneficiary designation. They just have a little bit of money in a savings account, but they had cash bequests in their will. And all of a sudden there's basically a set of rules about who gets what if there's not enough money to fund all the cash bequests. And so it's something to think about when you're and talk to your attorney about when you're putting a will together. Not saying you can't do it, you just have to be thoughtful about how it's titled. Um, Other important parts of a will, testamentary trust. So a testamentary trust is a trust that's built into your will for a beneficiary. So this most commonly comes up when people are leaving gifts for grandkids, and it can be, everything to my kids, but in the unlikely event one of my kids has predeceased me, leaving, children, they're my grandchildren. I want my share for my child to go to my grandchild in a trust for their benefit because we don't want minors or even young adults inheriting money. And so we'll do that by building a trust into the will that only comes into play if it's needed. So it's not a standalone trust. It's just trust language that's built in there if it's needed. And the second most common reason is for a supplemental needs trust. So a trust for someone with a disability. We want to make sure that their inheritance doesn't kick them off of their public benefits. And then the most important part of the will is what's called the residuary. So what happens to everything else? And this is usually where it says everything else to my spouse or everything else to my kids, everything else to my nieces and nephews. The last part of the gifting part of the will is the contingent distribution. So what happens in the unlikely event that I've taken my whole family on vacation and something tragic has happened? Who gets my stuff? And often people will pick more extended family members like siblings or a charitable organization. So again, lots of flexibility for what you can build into a will that really can be tailored with whatever you need for your family. Let's talk about, that's what happens to my stuff, but we also talked about your fiduciary nomination. So who's going to be the trustee if I do have a share trust for a grandchild of mine? Who's going to be the PR of my estate? Again, you want to think about who in your family is really organized, who in your family gets along with everyone, right? Not, they don't have to get along with everyone, I guess, but is going to be able to guide your family through this process with the help of an attorney typically to get your estate administered. Again, you want to think about nominating guardians or conservators for minor or disabled children, and then making those important nominations for who's going to help take care of things after you pass away. Okay, trust consideration. So do you really need a trust? There is something called a Medicaid trust, which is when you transfer your assets to an irrevocable trust to try to shield them from your long-term care costs. But trusts are also tools that people use just for their general estate planning, and those are typically revocable trusts, meaning that you have a trust that you can restate or revoke at any time. A trust is technically an agreement between the settlor, which is the person who establishes the trust. There has to be a trustee, and usually you're your own trustee during your lifetime. And then beneficiary. So who is going to benefit from your trust after you pass away? The most common reasons to have a trust are one, privacy. So, in Maine, a will is technically a public document. When you pass away, your original will is delivered to the probate court in the county where you are residing. For administrations, the probate court docket is online. I don't really hear about often people going to just look up wills, but they're technically public documents. And so sometimes um, people, for whatever reason, just need privacy regarding their estate plan, and the best way to do that is through a trust. The second most common reason is for families that have real estate in multiple states. So if you live here in Maine, but you have a camp in New Hampshire and you pass away and the camp has no co-owner, it's just in your name, you have to open probate here in Maine and then open what's called ancillary probate in New Hampshire. And then you're basically having two administrations. In most cases, you're doubling the cost. And so if you can put real estate in other states in your main trust, and that means that you don't have to open probate, and it's considered an asset of the trust, and will pass under the trust terms when you pass away. Probate in New Hampshire and Massachusetts is really, really complicated and formal. Well, I don't want to say really, really complicated, but it's more complicated than it is here. So you will hear things from, if you have family in those states or other states, you might hear, I want to do it for probate avoidance. You have to get a trust for probate avoidance. And that's not necessarily true because we have informal probate here in Maine. Assets more readily available. Yeah, so when someone passes away and their assets are in a trust, they're often, still accessible during the trust administration. Whereas with probate, your assets do get tied up for a couple months. It's not very long, and it's not, for example, if you have an account that's in probate and that's where your mortgage is paid out of, like the banks all understand, it generally really isn't that enough of an inconvenience to warrant setting up a trust. So again, it's for deciding whether to have a will or a trust, it's really important to sit down with an estate planning attorney and talk about the specific situation with your family. Um, Trust. I need one because my neighbor told me so. I feel like so much legal and financial advice comes out this way, right? Where it's like fear-based. Someone is like been, scared you into thinking you need to do this thing because they've done it. So I hope I can disabuse you of this for at least for the trusts. Like some families need them, many families don't. And then consideration, costs of drafting and funding. It generally costs more to have a trust set up than to have a will set up. And then you need to be careful about how assets are titled, whether you want to retitle them in the name of your trust now or not. Certain trusts have to file separate tax returns. Many revocable trusts don't. But again, there's just more considerations for then managing the trust after it's established. And you're going to want to talk through those considerations with an attorney to decide whether that's appropriate. And then the other thing is sometimes people set up trusts. A family member is the trustee after they're died, and the family member trustee doesn't do what they're supposed to do. I've had this happen a couple times in Maine where it's like, wait, I just learned that our family camp was in a trust and it was supposed to go out to all of us at mom's death, but the trustee just, didn't tell us that or didn't do it. And then you have to kind of untangle it. Whereas a will gets filed and we would be public, so it'd be harder to hide anything along those lines. So, yeah, lots of considerations that are really specific to each family situation. Again, this is more part of the Medicaid conversation, but for those Medicaid trusts, it's difficult to take out a loan if you have real estate in there or like home equity loan or mortgage. If you have an existing mortgage that you transfer in, that's fine. There's a federal law that allows you to do that. And then there's property tax relief programs available. Sometimes you can still get those programs if your real estate isn't a trust. It depends on the type of trust. So my big takeaway for you guys here, I guess, is, you have it messed up if you don't have a trust. And next time someone tells you you definitely need one, now you know it is really a case-by-case basis. And for many, many families in Maine, where their family members get along, they don't have real estate in another state, they don't have serious privacy concerns, just having a will is going to be fine for them. I want to very briefly touch on another big topic in estate planning, which is estate planning for a disabled beneficiary. So this is another area people said, I have to, if you have a disabled beneficiary, you have to do a special needs or a supplemental needs trust for them. Um, a decade ago now, Congress passed the Achieving a Better Life Experience Act, which allows, let me back up. It used to be that if you were disabled and on public benefits, you could only have so much money in your name, and it was very, very difficult to save money. These new so-called ABLE accounts allow people with disabilities to save money without being kicked off their benefits. So there's a big change that's going to happen at the end of the year. It used to be that your disability onset had to be before the age of 26. That age is going up to 46. So if your disability started before age 46, you can use this type of account. The annual deposit limit this year is $19,000 plus an additional 15,000, and it's 15,060. I think that's adjusted for inflation. That's why it's a funny number, of wages. And this is a great tool to help save money, or for your loved one to help save money. And you can, if you have a disabled child, you can make distributions into or gifts into this type of account for their benefit. The funds can only be used for qualified disability expenses, but this is actually a very broad category. I think the phrasing is something along the lines of like any way in which the disability impacts your life. So housing is okay, transportation is okay, food is okay. Again, it's something you'd want to visit with an attorney, but you're able to use the funds in this account for many things. So again, this trust or the ABLE accounts can only have 19, or I guess now it's about $30,000 total added to them this year. So sometimes people want to make larger gifts for the benefit of a disabled beneficiary, and that's when you want to consider using a supplemental or a special needs trust. Again, kind of the details of this are a little bit of outside of the presentation today, but I want you to know that this is a planning tool that you have. There are two major types of this trust. So one is what's called a third-party special needs trust, where you're a third party is putting money into a trust for a separate person to be the beneficiary of who has a disability. There's also something called a first-party special needs trust, where the disabled person is putting their own funds into the trust. So this sometimes comes up with like personal injury cases where someone's been injured. They now have a disability, and the money from the lawsuit is going to them. We're going to put it into a trust for their benefit. And it's a first party special needs trust. It has special drafting rules. So again, a little bit beyond the scope of our presentation today, but I really want to have this on your radar if you have loved ones in your life with a disability and you're doing any planning for them. Trying to think of what else. Those testamentary trusts we talked about earlier, where you can have a will that has a testamentary trust in it. You can have a testamentary supplemental needs trust. So yuck, that was a lot of legalese, but you can have a will that where you leave a gift to a disabled beneficiary in a supplemental needs trust that's built into your will. And so you can make sure that your disabled beneficiary is not going to be kicked off of their benefits, because there's ways to deal with that, but it's not, again, you have to go to the probate court. I just had someone come to me on Friday where they were like, I didn't expect, my daughter's aunt to name her as a beneficiary for her retirement account. That's amazing, but it's going to jeopardize her eligibility for public benefits. And, we think of public benefits, I think generally as like, I get some money from the state every month. But it also can be people's main form of health insurance. And so that's a big deal if you are going to lose your health insurance because of an inheritance. So it's really, really important to kind of be thoughtful with this type of planning. Okay, just to wrap us up, and then I'm going to leave some time for questions. What is the deal with probate? So at a very basic level, probate consists of collecting assets of a decedent, paying, settling debts and liabilities, and distributing the remaining assets to the beneficiaries pursuant to a will. Most estates in Maine can be handled at a very low cost within a reasonable time period. It provides a structure for the settlement of the decedent's affairs in business, which provides protection and finality for family and fiduciaries. So we are very fortunate here in Maine to have informal probate. I will just very briefly kind of walk you through, and we've already touched on it a bit, but what probate looks like from, a big picture perspective. Since this is probably the second biggest misconception is people will tell you, oh, you have to do this because probate is a nightmare. Probate is a nightmare. My dad just said this to me. I was like, Dad, how many times are we going to have this conversation? Okay, so someone passes away, you file their original will. There's a probate court for every county in Maine. So we have 16 probate courts. You file the original will and death certificate. With the probate court, there will be some filing fees. And then again, if everyone gets along, no one is fighting, then the register will issue what's called letters of authority for your personal representative. That's what allows your personal representative to go out and administer your estate. They'll give notice to the interested parties of your estate that your probate has been opened. This is a little old-fashioned, but there also will be a small notice in the newspaper that starts a 4-month creditor claims period. It's one of the shortest creditor claims periods in the country. It means that any creditors of your estate only have 4 months to file a claim against your estate if they have some sort of debt to be paid. The nice thing about this, of having a short creditor's claim period, is that for most estates, once that 4 months, during that 4 months period, we're gathering information on the assets, we're selling real estate if we have to, and we're getting things in line. And as long as we have a good sense of where things are at the end of the 4 months, you can start working on an accounting of the assets and wrapping things up for distribution. It's one of the fastest timelines in the country. Again, you're going to take an inventory of the assets, identify the beneficiaries, file the decedent's last tax returns if that's needed. And then you're going to do an accounting of the estate administration, everything that you collected, all the expenses of the estate, and then you'll do a proposed plan of distribution to the beneficiaries and typically get their sign off, like, okay, this looks good. And I'll tell you, for most families who get along, they can waive the accounting requirement. And instead, the PR will just send out estate bank statements to everyone so they can look through what the income and expenses were. And then after that, you're distributing the assets and then closing the estate. You can't close the estate before, I think it's 6 months after probate has opened or 9 months after the decedent's date of death. It's two things. I'd have to go look at that. But what typically happens is we're basically done. We've administered the estate, we've distributed the assets, we've done the final tax return, and we're just waiting for that timeline to lapse, and then we can file this sworn statement to close the estate. But we're very, very fortunate in Maine to have informal probate. This looks really big on my screen, but to wrap up, again, my big takeaways, I think, for you guys today are those inexpensive but very valuable estate planning tools, the Advanced Healthcare Directive and the Power of Attorney. Trusts, a lot of misinformation there about trusts. If your neighbor tells you you have to have a trust, you tell them you came to my presentation and it's not necessarily true. In informal probate, we do have informal probate in Maine. Doesn't mean that you don't have to think about all of this, but it means that you have more kind of planning opportunities than you might have in states where you really do need to avoid probate. And again, like this says, every individual is different, every family is different. You definitely want to design something that's going to work best for you and your family. If you're interested in getting an estate plan done, you would call reception. We have an intake coordinator. That's a really important part of our firm, someone you can talk to who doesn't have an hourly rate, so you can ask questions of and they'll get you, Shannon is her name, she'll get you the client questionnaire, get you scheduled for a consultation. We don't do any flat fee work. So my hourly rate this year is $275. Because I've done so many estate plan, typically what happens is a family, and I'm just going over costs at this point because I get that question often. I sit down with families and we design a plan. And then because I've done so many of these, by the end of that first meeting, I have a pretty good sense of what the fees will be based on the plan. So again, it's really different depending on if it's like a single person, a married couple. I'd say probably around, I don't like to give numbers, but it's not uncommon for an estate plan to be about $2,000 from start to finish, um, depending on what you have going on. But again, saves a lot of expense and stress on the family down the road. Yeah. Generally speaking, where your beneficiaries are not is not going to negatively impact any type of planning. So a couple other questions I had come in. One was how often should someone update their estate plan? Um, it's good to have an attorney look at it every couple years. Life is busy, so it's not uncommon for people to, do their estate plan when they first have young children and they're like, oh my God, I have to name my guardian and conservator, for my kids. And then when the kids have gone to college, they've come back and be like, oh, it's time for us to look at, life is busy. I get it. I would just say, if you've had a big life change, so if you have, you do end up having a child who has a disability, things like that. If you're even questioning it, it's worth it to have an attorney look at your documents, but I say every couple of years. It's not uncommon for me to sit down with folks and talk about their goals and say that everything looks good.